wait after the FDLE, like I was told by.
Okay, so we'll do we're going to call the FDLE person, and then if we need a quick break because Sergeant Callenberg can't be here, I'll just tell them that we need a quick break, and we'll get that taken care of. And then in terms of, and I don't want to know what Mr. Bastian's going to do. Do you have any other defense witnesses?
Judge, that's a conversation I'll have with Mr. Bastian at the end of this case, but I don't have any other listed witnesses. So
Okay.
I'll have the sergeant should be a minute, and then the records, and then we'll have the conversation. If he testifies, to be no more than 30 minutes.
Yeah, and again, I didn't want to know his decision. It was more, did you have anybody else as well? And then we'll go from there. And we can do closings, and if we can get it to the jury this morning, that'd be great. All right, anything else we need to talk about? Hearing none. Can we bring them down?
Oh, I'm gonna need exhibit 3.
Sorry?
Exhibit 3.
Exhibit 3. Oh, bro.
No, you don't. Lectern should be there because it's witness.
It's gonna be 7.
You're welcome. And if I didn't say it out loud, YouTube is up and running already. I did not have it up during my pleas a little while ago. Hey, everyone, please be seated. Good morning, ladies and gentlemen. I very much appreciate you being back. I appreciate you being timely. I have to apologize. I don't like to keep people waiting. I sometimes try and squeeze things in at 8:30 for other cases, and I misjudged the amount of time I was going to need. So it's my fault that we're starting a little bit late. I had a couple things that ran over, and I'm sorry about that. I try very hard not to do that, but sometimes I screw up. So that was on me. Sorry about that. As I mentioned before, I'm going to ask you 4 questions. Did any of you speak to anyone about this case during the break? Any of you conduct any research, internet or otherwise, regarding this case or any individuals or places related to this case during the break? Any of you read, view, or listen to any media reports or newspaper articles about this case or about this trial during the break? And finally, did anyone contact you regarding this case during the break? Thank you all very much. And again, I apologize for us starting a little later than I anticipated. Okay, Mr. Fraser, Mr. Scuderi, who's next? Okay.
Do you solemnly swear or affirm testimony you give shall be the truth, the full truth, and nothing but the truth? Yes, I do.
Mr. Scuderi, whenever you're ready.
Could you please state your name and spell your last name?
Tamara Monville, Monville.
And who are you employed by?
I'm employed by the Florida Department of Law Enforcement at the Fort Myers Regional Operations Center.
And how long have you been employed by the Florida Department of Law Enforcement?
I've been there almost 22 years.
And what is your job title?
I'm a senior crime laboratory analyst assigned to the chemistry section.
And how long have you held that position?
I've been an analyst for all but 6 months and a senior since 2013.
You've been an analyst for over 20 years.
Yes, I have.
And what are your job duties?
My primary duty is to analyze evidence submitted by local law enforcement agencies for the presence or absence of a controlled substance.
And what is your educational background?
I hold a Bachelor of Science degree in chemistry from Arizona State University, as well as undergoing an intensive training program with the Florida Department of Law Enforcement.
And I know you've been an analyst for over 20 years. Has that entire time been analyzing substances for controlled substances?
Yes.
And about how many times have you done that, do you think?
Somewhere between 22,000 plus times.
And have you analyzed certain substances to determine whether or not they contain heroin?
Yes, I have.
Do you know how many times you've done it for heroin? Or?
Well over 1,000.
And have you testified previously regarding the analysis you conduct?
Yes, I have.
Approximately how many times?
Approximately 180 times in trial.
And has that been in multiple counties?
Yes, it has.
And were you submitted evidence by Cuyahoga County Sheriff's Office regarding Jeff Bastian?
Yes, I was.
May I approach the witness, Your Honor?
You may.
Ms. Monville, if you could look at what's been introduced in the evidence that states exhibit number 3, do you recognize that?
Yes, I do.
And how do you recognize it?
I recognize it by the unique Florida Department of Law Enforcement case number, as well as the seal, as well as my seal, markings, and initials.
And when you first get that package, is it sealed by the Cuyahoga County Sheriff's Office?
It was sealed when it came in, yes.
And what do you do with it?
I store it in my evidence locker until I'm ready to proceed with the analysis.
And at some point, did you proceed with the analysis in this case?
Yes, I did.
Could you explain to the jury how that's done?
I begin by taking inventory of the evidence and taking notes on it. And then I begin by weighing the evidence before I proceed with my sampling. Then I sample the evidence and run my tests and make a conclusion.
And when you sample the evidence, what tests do you run?
In this case, I ran 2 instrumental tests as well as 2 color tests.
Now, could you explain the instrumental tests to the jury and how they work?
The instrumental tests allow me to make the identification. There's the mass spectrometry test and the gas chromatography test. Mass spectrometry test is where a small amount of samples introduced into an instrument. It's broken up into tiny little pieces. Those pieces are displayed in a graph, in the form of a graph similar to a bar graph by their weight, and it's a unique graph to each substance. I compare that with a standard or a known sample of the substance and make an identification from that. The gas chromatography test is where a small amount of samples introduced to the instrument. It travels down a long, thin tube. The amount of time that it takes to come out of the instrument is displayed on a graph. Then I also run a known standard or a sample or a standard, which is a known sample. And that comes out and gives a time also. So that's a time match that I make with that.
And the 2 color tests?
The 2 color tests are just screening tools that I use. They just give an indication of whether a substance may or may not be present.
And how do you know that your instruments are working correctly before you put a sample through them?
Our instruments are quality controlled every week.
And were you able to determine what State's Exhibit 3 in fact was?
Yes, I was.
And what was that?
The item contained heroin.
And you stated you also weighed the item.
Yes, I did.
Is it weighed in the bag or separate from the bag?
It is weighed without any packaging.
And what was the weight of the heroin in this case?
It was 6.96 plus or minus 0.14 grams.
So it was over 6 grams.
Yes.
And how do you know that your scale is working properly?
The balance that I use in the laboratory is performance checked each week by myself with known certified weights, and it's also certified by an outside vendor once a year.
And if you could look at State's Exhibit number 7 for identification, do you recognize that?
Yes, I do.
And what is State's Exhibit number 7?
That is a copy of the report that I prepared in this case.
Your Honor, at this time I move State's Exhibit number 7 for identification into evidence.
Any objection? Okay, State's Exhibit number 7 will be admitted without objection. Okay. Any cross?
Good morning.
Good morning.
Is the heroin the only substance that you were asked to analyze?
Yes, it is.
Okay, and you don't determine what you analyze, correct? Somebody makes a decision of what they send to you and you just process whatever comes in that evidence bag.
Yes,
And in this particular case, the only substance that you received was the heroin.
that is correct.
Now, you're not able to make any other testing regarding fingerprints or anything like that, just off the substance, correct?
That's correct. I just analyzed the substance itself.
Okay, thank you.
Any redirect?
No, Your Honor.
Okay. Can I let Ms. Mongol go? Or do you need her to stick around?
No, she's released.
Okay, thank you, ma'am. Have a great day.
Okay, thank you.
Okay, and that brings us to what we talked about a few minutes ago, yes? All right. Ladies and gentlemen, we have one witness who can't be with us until 10 o'clock, but hopefully he'll be here a little bit early. So we're going to take a break. We're going to try and do some work without you. So we shorten up the time later on that we have to do some work without you. But in the meantime, we're going to have you go back, and as soon as the witness is here, we will get you guys out and we'll get started up again, okay? Thank you very much.
All right, so jury, please.
Trying to make sure you get your steps in today. You're welcome. I sit a lot. All right, jury's clear. Everybody please be seated. Is there anything we can do in the interim? I know we normally wait until after everything's done to talk about the jury instructions or any of those things, but is there anything that we can do in the meantime?
Judge, I think that we can probably go through the jury instructions in substance, and we may have to review a couple of the issues that would come up, you know, whether the defendant testified, statements of the defendant, any affirmative defense. But for right now, we may be able to knock out the majority of that if everybody's able.
Okay. Ms. Upson? Okay.
Yeah. Copy?
Yeah,
You do?
I mean, I have what you said
Okay.
originally.
And I have a copy for
I was gonna say, I have one back from December, so I'll take what you got, and that way we've got it.
That's
this.
what I have.
Okay. The majority of it's the same, and I can give this to defense.
Well, you need it.
No, I've got it on my computer. I did make some changes this morning, so there are going to be multiple pages for the possession of controlled substance and trafficking,
Okay,
because those do include affirmative defenses, and then there are multiple copies of some of the instruction having to do with defendant testifying or defendant statements.
so why don't we do the ones we can, and then if there's other ones that we have to wait until after the defense is over, that's great, but we can at least knock out some of the ones that are here.
The only thing, Judge, is I guess I would want just a minute to read if there's been changes.
If there's changes, absolutely. Yeah, go ahead.
So I don't want to rush through and then.
I don't want you to rush through either. So, Mr. Frazier, are the changes you made, like, I'm looking at 25.7A, you have one that has no affirmative defenses and one that has the affirmative defenses.
Those are the only changes. It's not changes to the substance of the instruction. It's more an additional copy with items removed. So affirmative defense, if there's no evidence of an affirmative defense, then we have the instruction without it available to be reviewed. And then the same with defendant statements or defendant testifying.
Okay, so it's basically the original jury instruction you sent out, except one page has some of the language removed, the other page doesn't.
That's correct, Judge.
Okay. And obviously whether or not the affirmative defense is going to be in there or not depends on what the defense decides to do, and I don't need to know, and that's fine. So I see what you did now.
The one significant change that I did make, Judge, and this was done this morning based on the state's evidence, is the original submission did have a lesser included for possession with intent.
Mm-hmm.
Based on the evidence, that would not be a category 1 lesser included, and the evidence would not support that as a lesser included. So at this point, the state would submit that the only lesser included for trafficking would be possession.
So, Mr. Frazier, based on what you just told me, there's one sheet in here between the traffic in heroin and possession of a controlled substance, where it says where there's lesser included crimes.
Yes.
You would want to remove number 1.
Correct.
Okay, because it's still on the sheet you gave me.
Okay, I'll
The-
remove
the-
that and we'll
the
make sure
intent,
that
right.
the final package. After the trafficking instruction, there's a sheet that says when lesser included offenses.
Yes.
It lists 1 and 2. Number 1, we're gonna delete that.
Just possession. Okay.
Yeah, possession would be the only lesser included.
And he's already pulled that jury instruction, but he didn't get rid of number one. So again, Ms. Upson, take a minute or two. Take your time. And in the package you gave me, Mr. Frazier, I don't have a verdict form.
Okay, I can print that out, Your Honor. That, because there were no changes made to it, I didn't print the additional one.
I apparently don't have it from the original either, so.
Okay,
So if you could print a couple of copies of that, so Ms. Upson can have one and I can have one, that'd be great. Corporal Smith, when the sergeant gets here, he won't come into the courtroom, correct? When the sergeant gets here, he won't come into the courtroom, correct?
No, he won't.
Cool.
He might still be out there.
Well, could we find,
Can we go check?
yeah, or if we could have somebody out there just so that we know when he's here, because then we can get started with him. I don't want him just sitting out there and us not knowing. I guess, Mr. Frazier, is the state, I didn't give you the opportunity. Is the state resting at this point? Or do you have any further witnesses?
no, Judge, the state is resting.
Okay, so we should have done that in front of the jury before I excuse the jury. I'm sorry. Then the other item we can talk about is whether the defense has any motions they want to assert, but keep reading your jury instructions, Mr. Upson. I don't want to take you off the game.
You want me to go to the state rest now or wait till the jury?
We'll wait till the jury comes back.
Okay.
We'll do it in front of the jury. Thank you. All right. Ms. Upson, have you had time to look through all right. Should we discuss, well, since we're on the roll, on the jury instructions, do you want me to run through the basic ones and you can tell me if you have any objections, and we'll flag the ones we need to talk about later? Okay. We'll let the printer stop. Mr. Frazier's giving us the verdict forms. Thank you. All right, let's talk about the jury instruction. We'll go back to the verdict form. So 3.1, introduction. Any objection?
No.
3.2, statement of the charges. Any objection?
No.
Okay. And we get to our first 25.7A, trafficking. Do you want to put this one on hold?
Yes.
Okay. Next up, when they're lesser included, any objection with the removal of paragraph number, or the numbered 1?
No.
Okay. And we'll put possession of a controlled substance on hold as well. And it's the same one for the marijuana charge. Any objection to 25.14, use or possession with intent for paraphernalia? Did you say no? I'm sorry. Okay. 21.2, resisting an officer without violence. Any objection? 28.11, driving while license suspended. Any objection? All right, when they're lesser included, the no valid driver's license paragraph. Any objection?
I'm sorry, where are you, Judge?
The one right after the driving while license suspended, there's a when there are lesser included crimes, no valid driver's license. Any objection?
No.
And then the no valid driver's license 28.9, any objection? 3.7, any objection? 3.9, weighing the evidence, looks like we need to leave that one. And 3.9A we'll leave as well. And 3.9B, any objection? 3.10, rules, any objection? 3.11, cautionary instruction, objection. 3.12, verdict, not the verdict form, the actual language, any objection? And submitting a case to jury, 3.13, any objection? All right, great. We'll go back to the other ones later, and we'll give you time to look at the verdict form at that point. Since the state is resting, can we talk about whether the defense has any motions they want to bring at this time?
What are we doing here, Judge?
So the state announced they rested. I'd like to hear what your motions are. We can do the official rest when the jury comes back in. But rather than have the jury come back in, have them rest, and then sending the jury back out. Okay.
Move for a judgment of acquittal on the possession charges. The state has not made a prima facie case of knowledge in this case. Their testimony, the testimony elicited from the officer established that there was having a closed container, and that area had not been observed for a period of time to discount the possibility that other people had been in there, and there is no evidence given to the court that Mr. Bastian knew what was in that box.
Okay. Mr. Frazier.
Yes, Judge. So the state's testimony and evidence presented was that there was no other passenger inside the vehicle, that no other person accessed the vehicle in the time that Sergeant Kallenberg had observed the vehicle, that the defendant had driven the vehicle, parked in front of a house, went inside, stayed for only a couple of minutes, came back out, that there was an odor of marijuana inside the vehicle. There was marijuana on the floorboard of the driver's side vehicle where the defendant was seated. There was marijuana inside of the box that contained the heroin, and that the box containing the heroin was sitting on top of a document with Mr. Bastian's name and other personal identifying information. That the way that the document and the box was situated on the passenger seat indicated that no other person could have occupied that seat. The state's evidence has established that the defendant was in exclusive control of the vehicle at the time that the defendant was arrested, and that there is circumstantial evidence between the marijuana dispersed throughout the vehicle and the defendant's document with personal identifying information being situated underneath the box containing the heroin, that the defendant was in fact in control of and had knowledge of the box and the items inside of it.
Okay. Ms. Upson, anything you want to add? All right. I do think that when I look at this in the way I'm supposed to on the judge, I'm going to deny the request for judgment of acquittal. I think they've put enough forward for the jury to make a determination. Whether the jury agrees with it or not is a totally different story, as you all know. Any other motions? Okay. Mr. Bastian, I do need to advise you of the right to remain silent. I want to make sure you have plenty of time to talk to Ms. Upson about whether that's what you want to do. You don't need to answer the question now. I just want to make sure that I advise you still have that right. And obviously you guys will talk at the end about how you want to proceed. I just got the thumbs up, which I take to mean Mr. Sergeant Kellenberg is here. Excellent. Okay, so we'll bring in the jury. The state will rest. We'll then have the defense start. How do you want me to handle it, Ms. Upson, when Sergeant Kellenberg is done? Do you want a minute to talk to Mr. Bastian? Do you want me to excuse the jury while you do that? Do you want to just look at each other and give me a thumb and tell me whether you're going to call another witness or not?
So in abundance of caution, I would ask you to excuse the jury, and then I can have a private conversation, and then I will.
Okay, that's
and then we can ask them on the record if
not a problem. Just want to make sure. Okay. All right. So that's what we'll do. We'll bring them in, and then once the sergeant's done, we'll excuse them again. We'll find out what's going to happen, and then we'll go from there. Yeah, Mr. Scary. Ms. Upson?
that's fine.
Okay. Yeah, I mean, the jury's not expecting us till 10 o'clock, so if we get started before then, that's a bonus, but if not, we're all good. So if you want them in the attorney-client room?
Yeah.
All right. Off the record, I'm gonna go use the restroom. We'll give you a few minutes, Ms. Upson. When you're done, come on out.
All right.
All right, we're back on the record. Ms. Upson, have you and Mr. Bastian had sufficient time to talk?
Yes, sir.
Okay, and how are we going to proceed?
But Judge, we'll have to wait until we put on our 2 witnesses to make that final decision.
Okay,
And if we decide that he's not going to testify, then I'll rest.
okay. All right, and then at that point in time, I'll ask you, you said 2 witnesses, but,
One witness and introducing my record, which is not a witness. But
got it?
I stand corrected.
And then you'll rest or you won't rest, and then I'll ask the state if you have any rebuttal, and at which point I'll excuse the jury again so we can finalize the jury instructions and get ready to go into closings. Okay, Corporal Smith, get him moving. And, yeah, they're back here. Yeah. I was gonna say, yeah, go ahead. And then when you're done, go talk to the sergeant. We won't bring him in. But he can come in with you when you come so that he's closer to be able to walk up when he's ready. Thank you. That's fine. You just hang out there for a second, Sergeant. We'll be right with you. You don't need to go back outside. You're good right where you are. Okay, we ready? All right, bring him in. All right, everyone, please be seated. Thank you, ladies and gentlemen. We were actually able to get some other things done so that we don't have to excuse you as long. We're still gonna have to excuse you in a little bit, but not as long as we would have to otherwise. So we were able to get some of our stuff done. So it worked out well. Okay, Mr. Frazier, call your next witness.
Your Honor, the state rests our case.
Okay. Defense, call your first witness.
We would recall Kellenberg.
Okay. And let's re-swear him because it's a new day.
You solemnly swear or affirm that when you give shall be the truth, full truth, and nothing but the truth? Thank you.
Okay, Ms. Upson, whenever you're ready.
Thank you. Good morning.
Good morning.
I have a couple of quick questions. When you took the information after Mr. Bastian's arrest, did you document identification numbers of the vehicle in any way?
Yes.
And in what documents did you memorialize those facts?
In the official document and then in the citation.
Okay, and it's part of your duty when you write a citation to document what vehicle was involved in that traffic stop.
Correct.
In this particular case, did you document the tag number of the vehicle that you saw Mr. Bastian drive?
Yes.
And can you tell us what that tag number is, please?
DFVJ72.
Okay. And my second question is, when you sent out the drugs to the lab, you sent out the heroin and not the marijuana, correct?
Correct.
Why is that?
If it's a misdemeanor marijuana, we do not send that to the Florida Department of Law Enforcement for testing.
Because you don't require an expert to determine it's marijuana, correct?
Correct.
But a substance like heroin, you do need a lab to determine it's heroin.
Correct.
That can't be established just from visual observation, correct?
It's sent so that it's made sure of what the substance actually is.
Okay, thank you. Nothing further.
Any questions for the sergeant?
No cross, Your Honor.
Okay, can I let the sergeant go?
Yes, Your Honor, state has no need for the witness.
Okay, thank you, Sergeant.
Thank you, Judge.
All right, Ms. Upson, who's next?
Sir, this time I would like to introduce the defense exhibit 1.
Okay. Any objection?
No objection from the state.
Okay, so defense exhibit number 1 will be admitted. Thank you, ma'am. Without objection. And you want to make a record of what defense exhibit 1 is, or do you want me to just put it in?
Yes, Your Honor, it's Avis record. It's Avis rental records of the vehicle involved. Includes the tag number that was identified.
Okay, great, thank you. All right. Call your next witness. That's okay. Call your next witness.
The defense restaurant.
All right. State, any rebuttal?
No rebuttal from the state.
All right. Okay, ladies and gentlemen, I told you I'm going to get you your steps this morning. I need to excuse you just for a few more minutes. There's one other thing we have to do, and then we'll go right into closings. So if you guys could leave your stuff, we'll have you back out in just a few minutes, okay? Okay, everybody, please be seated. All right, let's finalize our jury instructions. And then we'll talk about how long you need for closings and we'll get ready. So, first one is the 25.7A for trafficking in heroin. We've got one with affirmative defenses and one without.
And Your Honor, the state would ask that the jury instruction used for the final charge exclude the affirmative defense, as there was no evidence from the defense as to the knowledge of the substance.
Judge, we would disagree. The state of the law is that if requested, an instruction for an affirmative defense needs to be given, even if evidence introduced is flimsy. In this case, the defense has presented that this was a rental car, that there is no one observed Mr. Ashton open the box, touch the box, see what's in the box. Additionally, the testimony from the state witnesses was that heroin is the type of substance that cannot be identified by just visual sight, unlike marijuana, so that there is sufficient evidence presented through the state witnesses. It's not required that defense put on the defendant to get the affirmative defense. And there is at least enough to request that affirmative instruction.
Okay, Mr. Frazier, go ahead.
I should cite Miller v. State, 35 3rd, 162. It's not particular to the fact that it does state the law of that it minor amount of evidence, however flimsy, would justify giving the instruction. It would be error to not.
Okay, Mr. Frazier?
Yes, Judge. So there's actually no evidence on record that calls into question the defendant's knowledge of what the substances are. The evidence on record is that the defendant was in exclusive possession of the vehicle at the time, that no other person was seen accessing the vehicle, that the item was not just in an area with his documents, but directly on top of his documents with no indication of any other person's presence. The evidence overall does not call into question whether or not the defendant had knowledge of what the substance was.
Judge, if I may respond.
Briefly.
I have Burnett versus State, 901 Southern 2nd, 925. That's the second DCA case in 2005. The subject matter of appeal in that particular case was the court's not supplying the affirmative defense instruction to the jury in that particular case. As in this case, Burnett's defense was based on a lack of knowledge of the presence of the substance and of its illicit nature, because the defendant's defense in that case was that the pills or the vehicle didn't belong to him. And that's similar defenses here, which we've alleged that the car didn't belong to Mr. Ashton. We put in evidence that the car actually was rented to someone else and was therefore legally in the hands of someone else.
Yep.
And based on that case,
Ms. Upson, I don't mean to interrupt you, but I'm going to give you the affirmative defense in both 25.7 on the trafficking and heroin case, and also possession of a controlled substance, 25.7. So if we could make that change on both of those, Mr. Frazier, I will allow those two. I do want to talk about it again when it relates to the possession of the marijuana claim. Is it still, are you still asking for the affirmative defense on the marijuana?
Judge, I mean, that's, yes, and I'll tell you why. The state hasn't differentiated. We've heard testimony about 2 different marijuana places, and how they've elected to present their case makes it, they've combined it both into a bag. It is our intention to argue that the 2 should have been treated different. So if they're going to find him guilty of what's in the box, then the same instruction would apply, because if the car didn't belong to him and he didn't have, I mean, that's the
Okay, I'll give it to you for 25.7 for the marijuana as well.
With that, Judge, the state would request the addition of a special jury instruction. I'm going to hand a copy to defense. I also have one for the court.
Sure.
This is from State v. Nugent v. State, 275 Southern 3rd, 721. This is a Florida 2nd DCA case, 2019. The citation's included on the document that the state shared with defense and the court. So the evidence on record in this case goes to show that the defendant was in exclusive control of the vehicle at the time that this offense occurred. Because of that, and because there is the presentation of an affirmative defense that the defendant did not have knowledge of the illicit nature of substances inside the vehicle, the state would seek to include this additional jury instruction.
Judge, I'm gonna need a moment to pull the case. This is the first I've
Yep.
seen this special jury instruction.
Go ahead. Mr. Frazier, while she's looking at that, why don't you clean up the jury instructions? If you haven't already.
Yes, sir. I'm working on that
Okay.
as we go along.
Sorry. I appreciate that. Thank you.
Yes, sir.
Ms. Hobson, how are we doing?
I'm still reading, but I'm sorry, my laptop died.
Okay.
Okay, Judge, thank you. I've reviewed the case. I really don't see how this case supports the giving of this instruction. In this particular case, the defense was similar to ours, and the court found that the court erred in not granting a judgment of acquittal. Vis-a-vis the reasonable hypothesis of innocence, which we have gotten rid of in our cases, so that's not an argument that the defense intends to make. So the law opinion, the special jury instruction is misleading because it doesn't articulate the current state of the law. First of all, we have established that the state could not prove that he had exclusive control of the vehicle. It's not the vehicle at the time of the stop. And his jury instruction is actually the jury. The standard jury instructions are sufficient in the state of the law. I just read Nugent, and Nugent doesn't